Good morning, everyone. My name is Christy McKenzie. I'm Assistant Coordinator of Neighborhood Services with the Department of Senior Services in Erie County. Welcome to our last week of our 2021 Summer Virtual Elder Law Day series. I would like to take a minute to thank those individuals who have helped make this summer series possible: our County Executive Mark Cars, our Senior Services Commissioner David Shank, and Karen Nicholson, the CEO for the Center for Law and Justice. This program will be recorded and available on YouTube shortly. And we ask if you have any questions to please type them in the Q&A panel and refrain from entering any personal information. Please allow me to introduce our guest speakers. Kevin Quinn is a supervising attorney at the Center for Elder Law and Justice. Mr. Quinn prepares advanced planning documents such as powers of attorney and healthcare proxies, living wills for his clients. In addition, he supervises the Housing, Consumer, and Income Maintenance departments at the Center for Elder Law and Justice. Our next guest speaker is Edward Robinson. He is a member of the Hurwitz and Fine PC, where his practice focuses on elder law, estate planning, and estate administration. Mr. Robinson is a member of the New York State Bar Association, the Erie County Bar Association, the Estate Analyst of Western New York, and Financial Planning Counselors of Western New York. He also serves as the Vice President of the Center for Elder Law and Justice and as a Director of the Western New York Coalition Pool Trust. Welcome, Kevin and Edward.
Thank you, Christine, and good morning, everyone. Thank you for joining us this morning to cover the presentation today, focusing on the new power of attorney law in New York State. I'm happy to be joined with Ed Robinson today to present on more of a background on the power of attorney for those who may not be entirely familiar with the document, and then also some of the recent changes that have been enacted this past June. A little bit of an agenda for today. Again, we're going to cover more of the introductory topics, focusing on the power of attorney. A lot of frequently asked questions that we see as practitioners, focusing on the POA. And then at that point, we could pause for any questions, and we will turn it over to Ed, who will focus on updates to the new law and what has changed and what, if anything, you may need to do. And again, we'll save some time at the end for some more questions also. So we will jump right in and start by covering what is a power of attorney. A power of attorney is a document that allows you to appoint one or more people to handle your financial affairs for you. One thing to note right off the bat, and we'll discuss when we get a little further, but the power of attorney does not allow someone to make medical decisions for you. That is an entirely different document. That would be in a healthcare proxy. This is more of a financial decision making that you can allow another to handle for you. The person you name to act for you is called your agent. You are known as the principal. So when Ed and I use those terms throughout the course of this presentation, the principal is the person granting the authorities, and the agent is the person who is receiving the authorities or acting on your behalf. You can choose to appoint up to 2 agents as well as 2 successor agents. Successor agents begin to serve if the primary agents are unable to perform their duties. One thing to note, if you choose multiple primary or multiple successor agents, you must designate in the power of attorney document whether you wish for them to act together or separately. So what we mean by this is, if we are going to require that our agents always be acting together, that means that they must be present together whenever they're conducting business on the principal's behalf. So if agent number 1 has to go to the bank to make a withdrawal or a deposit, in order for the bank to work with agent 1, agent 2 has to be there as well. This is something to consider if you're appointing agents who perhaps live far apart. If they're not in the same geographic location, it might be tough for them to always act together on your behalf. So you would want to consider the possibility of allowing to act separately, which means that only one agent would need to be present to serve as your power of attorney. The power of attorney law became effective in New York in 2009. There were changes made in 2010, and most recently in June of 2021, which is what the focus of our presentation will be on today. Who can complete a power of attorney? In order to complete a power of attorney, you must be at least 18 years of age and be able to understand what a power of attorney is, which we refer to as mental capacity. Mental capacity is referred to as the ability to comprehend the nature and consequences of the act of executing, revoking, amending, or modifying a power of attorney, or the authority of any person to act as agent under a power of attorney. So basically, as a practitioner, what we want to make sure before we present a document for a client to sign, we want to make sure that they fully understand the document, that they understand the authorities that they're giving to another individual before we go forward with signing it. The power of attorney is a very powerful document, and it's also very useful, but we want to make sure that our clients fully understand exactly what they're conveying to another individual by signing it. If we cannot meet that threshold where we believe someone has the requisite mental capacity to sign the document, we obviously cannot go forward with presenting it. And in that event, maybe perhaps the only other way where an individual can serve on someone's behalf to have that legal authority would be through a guardianship proceeding, which can be lengthy and costly. So something we always advise our clients is that it's never too early to consider signing a POA as long as you have reliable and trustworthy agents to assist you. One of the more popular questions that we get asked is, can I still manage my own finances after I sign a POA? And the answer to that is yes. Signing a POA does not relinquish your own ability to manage your own finances. Signing a POA simply allows one or more agents to assist you. The document becomes more particularly helpful if you're ever in a state where you're unable to manage your finances. So when your agents sign the document and you sign and follow all the execution requirements that we'll get into, your agents can begin acting on your behalf immediately. But it's important to remember that you can still manage your money and your property as well. Again, you're just adding someone to help you. Can a POA be revoked? Yes, powers of attorney are not set in stone. They can be revoked at any time by the principal, so long as they have that requisite capacity that we spoke about. This is completed by executing a revocation form. It's important to note that in order for the revocation to be effective, it must be delivered to all of the agents, as well as any third parties who may rely on the document, such as banks or other financial institutions. So if I choose to revoke my POA and I serve it upon my agent, they're on notice that it's been revoked, but I also need to give it to any other entity who my agent has been doing business with so that they know that it's been revoked as well. Additionally, the power of attorney document automatically terminates upon the passing of the principal. At that point, if the individual had a will, that's the document that we would look to for someone to step in and make distributions of an individual's property according to the instructions in the will. Choosing your agent. This is a very important conversation that we have with our clients. The POA is a very powerful tool where you can give someone unlimited access to your finances. While this document is of great value, it's essential that you consider choosing a trustworthy agent. Unfortunately, we've seen many cases where agents have taken advantage of principals by accessing their bank accounts and acting in their own best interests instead of the principal. So some questions to ask yourself when considering who to choose as your agent. One, is this person financially responsible for their own affairs? If they have financial difficulties and having a hard time managing their own finances, then they may not be the best candidate to serve as your agent. Is this person close by so they can effectively manage my finances? Can this person get to your bank or other financial institutions that you have accounts with? That's also a factor to consider when choosing an agent. And lastly, will this person always act in my best interests and never for themselves? Agents have a fiduciary responsibility to always be acting in the best interests of the principal. But like I said, unfortunately, we do see from time to time cases where agents act in their own interests. And so we really want to make sure our clients are thoroughly considering who would be a best candidate to serve as their agent so that their affairs can be taken care of and they won't be exploited financially. The rights of a principal. Remember, you can still manage your own finances, even though you've appointed your agent through a POA to assist you. As the principal, you have the ability to request information from your agent at any time. You can ask your agent for copies of bank statements to make sure that your money is being spent properly. Your agent must provide these records to you. Your agent must keep receipts and records of any transactions that they're conducting on your behalf. And again, whenever those are requested, they have to be provided to you. Though they are rarely used, you may also appoint a monitor. A monitor is a third party who oversees the work of an agent. This is something that we've rarely seen at the Center for Elder Law and Justice in our documents that we've used. Typically, what we advise folks is if you have a trustworthy agent and you're confident they're going to effectively serve as your agent, we would recommend you just allow them that ability. However, there is an option in the power of attorney document that allows for an appointment of a monitor to oversee the work of your agent. So next, what authorities can I give my agent? The power of attorney document can be very broad in the authorities that it grants, or it can be very specific. This is the list of authorities that is included in the document itself, and we'll go through them now. Real estate transactions, so your agent can have the ability to buy, sell real estate in your name. The ability to manage chattel and goods transactions, which is your personal belongings. Banking transactions is one of the larger authorities and more useful authorities we see. The ability to manage a principal's bank accounts. Bonds, shares, and commodity transactions, business operating transactions, insurance transactions, estate transactions, any claims and litigation. So if the principal were ever involved in a lawsuit, the agent can retain counsel on their behalf to manage that litigation. Personal and family maintenance, which is something we'll get into in a little more detail, but essentially what that means is you can allow your agent to make gifts that you would typically make throughout the course of the year. So if you make charitable donations during the holidays and you are unable to continue making those, your agent can make those gifts on your behalf. Benefits from any government programs or civil or military service, financial matters related to healthcare records, reports, and statements. Again, that's financial matters related to healthcare. Again, it does not allow for agents to make medical decisions regarding your treatment. It's centered around the financial matters related to healthcare. Retirement benefit transactions, tax matters, all other matters, and lastly, you can allow your agent the ability to delegate their powers to another person. So if your agent, for instance, were to be out of town or unable to serve for a specific period of time, they can delegate their authority to someone else so that your affairs are still being managed while the agent's unavailable. So what you can do with these lists of authorities is select only certain ones that you would allow for your agent to handle. Typically, we would recommend that our clients consider all of them so that it's all encompassing and that every authority is taken care of. So down the line, you can trust that your agent has the ability to manage any type of financial matter that may come up. Is my POA valid if executed in another state? Yes, as long as the power of attorney was validly drafted and executed in another state, it should be recognized here in New York. Likewise, a validly executed New York POA should be honored in other states as well. So if you have executed a POA here in New York and you spend time in Florida in the winter, your power of attorney should still be valid and upheld in other states, so long as it was properly done in the state it was drafted. How long will my POA last? The POA will last until the principal dies, the POA is revoked by the principal, or an agent's authority is revoked with no successor agent to step in. So if I have one primary agent and one successor agent, and I want to revoke the authority of my primary agent, I can do that. And my successor agent would then fill the role as my new agent. If there's no successor named, however, or there's no co-agent named, then the document would essentially be void at that point. If the agent dies, becomes incapacitated, or resigns with no successor agent to step in, then again, the document would be void. If the agent is a spouse, the POA will terminate in the event of a divorce, again, so long as there's no other co-agent or successor agent who can fill that role. Okay, so before we change over and Ed jumps into the updates, do we have any questions? Okay, I don't see any. So at this point, Ed, if you want to jump in.
There's been a power of attorney statute that has existed for decades, but there have been two major changes in law to the document. One occurred in 2009 and 2010, and then a new law went into effect as of June 13th, 2021, which made some changes to the prior law. It was supposed to make things easier. I'm not really sure that it's really easy. Our power of attorney is like 8 pages long, so it's not a short document, even though it's referred to in the law as the short form. So it's kind of a misnomer. It's not really very short. But in any event, even though the law changed in June, powers of attorney that existed and were properly signed and so forth prior to that date are still valid. So if you have a power of attorney that you signed in, for instance, 2010, then that power of attorney is still valid. You don't have to do a new power of attorney. If you are looking to have a new power of attorney in place, you should really speak with an attorney. I've seen a lot of documents that people find on the internet and so forth. Most of them do not follow the statutory form, which really has to be followed in order for the document to be valid. So the power of attorney statute provides instructions as to what should be contained in the document. And it's pretty specific. And if the new law provides for slight variations from the statute, but only slight variations. And if the form that's being used doesn't substantially comply with the law, it's not valid. So we'll go on and talk about some of the requirements that it takes to make a valid power of attorney. Okay. So again, I talked about this being a so-called statutory short form, even though it's not very short. And I also mentioned that in the 2010 law, the powers of attorney had to have the exact wording from the statutory short form. And if it did not have the exact wording, it would be invalid. Under the 2010 law, they had to be signed and dated with the principal. And as Kevin mentioned, this is always the case. The principal has to have capacity. So the principal had to sign and date the document, had to have capacity, and then the principal's signature had to be notarized. The 2010 law created a what was called the statutory gift writer. The gift writer allowed the agent to make gifts of the principal's assets during the principal's lifetime. And that was pretty broad authority, which could be used for a number of different purposes. One of the purposes would be, as Kevin mentioned before, if the principal was used to making charitable contributions, like giving money to his or her church, different charitable organizations, or customary gifts to family members, like money for Christmas, birthdays, anniversaries, and so forth. If there is a gift writer in place, the agent would be able to continue that pattern of gifting in the event the principal was incapacitated. Another purpose was for tax reasons. If the principal has a taxable estate for estate tax purposes, the agent would have the authority under the statutory gifts writer to make gifts of the principal's assets to decrease his or her estate for estate tax reasons. And then finally, probably a common reason for granting the agent the authority to make gifts under a gift writer was to allow the principal to make gifts in the event the principal ended up in a nursing home and the agent engaged in some planning to make gifts to family members, so not all of the principal's money would end up going to the nursing home. And that's probably the primary we would clients were interested in executing the statutory gifts writer so that the agent would have the ability to make those gifts for Medicaid planning purposes. The agent ends up the principal ends up in a nursing home. So we'll get into the changes that were made effective by the 2013-2021 change in law. The document now needs to be signed, initialed, and dated by the principal. Again, the principal always has to have capacity, or in the name of a principal by another person other than the agent or successor agent in the principal's presence and at the principal's direction. So what that means is this: if we have a principal who is unable to sign his or her name, but directs somebody to sign his name, then that person can sign on behalf of the principal. And just to give you an example, a couple of weeks ago, I met with a client who has full capacity. He absolutely knows what's going on, but he's suffering from a physical disability where he just can't sign. He can't even hold a pen. So he directed a person to sign the power of attorney on his behalf. And this is valid under the new law. It was not valid under the old law. Okay, so I talked about the fact that the new law says that the power of attorney form doesn't have to have the exact wording as the statute provides. And again, under the prior law, not having the exact wording would invalidate the document. Now there's the idea that the power of attorney has to substantially conform to the statute. And what that means was substantially conforming means that if there's an insignificant mistake in wording, if there's a spelling error, the punctuation isn't correct, or there's the bold or italic type doesn't conform with the statute, it's okay. And if the document uses the language that is pretty much the same as, but not identical to the statutory form, including utilizing language in the prior document, it's still okay. Under the old statute, it was really required that the whole statutory form, and what I mean by that is the law provided a form that you had to use in order for the document to be valid. The old form was like 8 pages long, and not all of the clauses contained in the form would be applicable. But if you deleted any of those clauses, the form would not comply with the statute, and that would invalidate the document. It would invalidate the power of attorney. Under the new law, if any of the clauses that are not relevant to the principle can be deleted, and as a result, the power of attorney is not invalid. It's still valid if irrelevant clauses are deleted. Okay, so I talked about the statutory gifts rider. The new law got away from and really deleted the idea of the statutory gifts rider. Okay, under the old law, there was the power of attorney, and if the if the principal wanted to give the agent the authority to make gifts, there was a second document called the statutory gifts rider. That's no longer applicable. But again, if you have a power of attorney that was signed prior to June 13th, 2021, and the power of attorney contained a statutory gifts rider, that's still good. Okay, so the new law is prospective, meaning that any documents, any powers of attorney signed on June 13th, 2021 or after no longer need the statutory gifts rider. Okay, but the new law still gives the principal the ability to charge the agent or grant the agent the authority to make gifts, just like under the prior statutory gifts rider. It's just that no separate document is necessary. Instead, the gifting authority is within the body of the power of attorney form itself, and there's a separate clause in the power of attorney which allows for the principal to make modifications to the form. And a modification can be the grant of authority to the agent to make gifts of the principal's assets during the principal's lifetime. And part of that is an indication as to who the recipients of the gifts should be, even the power of attorney, him or her, I'm sorry, the agent, his or herself. So, for instance, the principal may be interested in a power of attorney which gives the agent the ability to make gifts to the principal's spouse or the principal's children. And if one of the agents happens to be the principal's child, the principal might want to give the agent the ability to make gifts to him or herself as a child, to be included in the class of the people who are authorized to receive the gifts. Okay. Without providing for that authority in the modification part of the power of attorney, the agent gifts of up to $5,000 per year, and those are cumulative gifts. Okay, so it's not $5,000 per person, it's not $5,000 per charitable organization. The total amount of the gifts annually can't exceed $5,000. So if the principal wants the agent to give away more than $5,000 potentially, then the modification section of the power of attorney has to be completed in order to give the agent the ability to exceed that $5,000 limit. Okay, so a real problem with powers of attorney in the past was the acceptance of the power of attorney by financial institutions. You know, let's give this example. The principal becomes disabled, has difficulty in handling his or her own affairs. So the agent steps in to make sure that the principal's affairs are being properly handled. So the agent takes the power of attorney to the bank and says, here I am, here's my power of attorney, I'm the agent, I need to pay some bills on behalf of the principal. And then the bank looks at the form and says, well, this isn't our form. So we're going to reject the power of attorney. We're not going to deem it to be valid, and we're not going to give you, agent, the ability to do anything on the principal's behalf. That happened, quite often, and would be frustrating for the agent. And if the principal had any capacity, it would be frustrating for the principal, because the principal would sit there saying, well, why did I go through the trouble of having this power of attorney prepared and signed if the bank won't accept it? Okay. So the new law says that if the agent presents a power of attorney to a financial institution, including a bank, the bank has a certain time period in which to either honor the power of attorney or reject it. And if the power of attorney is rejected for no good reason, I mean, there are reasons why the financial institution could reject the power of attorney, like if the financial institution has some concerns that the principal was not mentally competent or lacked capacity at the time the power of attorney was executed, then that would be a good reason to reject the power of attorney. But if it's rejected for no good reason, like it's not our form, and frankly, their forms do not comply with the statute, then the bank is subject to monetary damages. Okay, so that's what it means, that they can be financially sanctioned. They could be held liable for damages. Any questions?
Thank you. There have been a couple questions coming in, may have related to Kevin's portion. I'm not sure who's going to answer, but the first is, can you select an agent who lives outside of the U.S.?
I believe you can. The only thing I would just caution is their ability to effectively serve on your behalf. I understand, some folks don't have anyone else that they can choose, but I believe they can still serve as an agent.
Okay.
Yeah, I agree.
And okay. The next question, does a monitor receive payment?
Not that I'm aware of. The power of attorney document does allow for agents to be compensated for their time serving. And I'm not sure if you've seen otherwise, but I know the document itself may not allow for the monitor to actually be compensated.
Yeah, I think the monitor can be compensated if that's what the principal wants, but that would have to be included in the modification section.
Okay. The next question, where can you get a valid POA form?
I would be and Ed touched on this at the beginning of his presentation, I'd be very cautious about finding forms on the internet. I think it's worth a consultation with an attorney, even to be sure you have the correct form. The statutory requirements, like Ed mentioned, have become a little more lax in that certain statutory language isn't absolutely required, but it still has to substantially conform. And in addition, you want to make sure that the document is tailored to your specific needs. So attorneys can really craft that to your specific need, and obviously make sure that the language conforms as well. So that'd be my best recommendation.
Yeah, I think that's right. And I think particularly because if there is gift giving authority, that has to be properly delineated in the modification section of the power of attorney. And if the more specific the grant of authority there is, the less chance there is of the agent going outside of the boundary of what the principal's intentions are. So to a certain extent, I kind of look at the power of attorney as almost like a will, in the sense that the will provides for who gets what at death, but the power of attorney, if gift giving authority is given, is really like there is no such thing, but I'm going to use this term, a lifetime will, because you're giving the agent the ability to make gifts during your lifetime, and you want to make that specific so that the agent knows who the recipients of the gifts are, the circumstances under which the gifts should be made, even maybe amounts of gifts and so forth. So that might be difficult to do as really kind of a layman who might not have the ability to spot all of those issues and take care of all those issues. So I agree with Kevin. It's probably a good idea because this is a fairly complicated document to consult with an attorney.
Okay, with that being said, consulting attorney, another question just came in. Will the Center for Elder Law and Justice help low-income people with a POA?
Yes, so our office does have certain age and income guidelines that we have to adhere to, but assuming those are met, then yes, we can help.
Okay. Is there still a distinction between durable POA and non-durable?
So the two types of powers of attorney that we see are a durable power of attorney and a springing power of attorney. The forms that we use here at our office are durable, meaning that the agent's authority begins as soon as the document is executed. A springing power of attorney is a different type where the agent's authority only kicks in upon some event in the future. Typically that could be when a principal is deemed incapacitated. At that point, it would kick in. At our office, like I said, we stick with the durable forms just because there can be some uncertainty as to when that actual event would trigger the agent's authority under the springing power of attorney.
Okay.
If I could just jump in, the statutory form is a durable power of attorney. Okay. The statute also provides for a non-durable power of attorney that can be executed for a specific purpose. So for instance, if I'm buying real estate and I find myself out of town at the time of the closing, I could sign as the principal a non-durable power of attorney, which just gives my agent the ability to sign those real estate documents on my behalf. And then once the transaction is over, that power of attorney is no longer valid because the purpose has been completed. So that might be an example of a non-durable power of attorney. But if it's a New York statutory short form power of attorney, it's a durable power of attorney.
Okay. Will SSA accept a POA?
Say that again?
Will SSA accept POA?
Oh. It's a really good question. You got an answer, Kevin?
I mean, they should, although that's not always the case. Sometimes it requires some advocacy on the drafter to make sure that it's recognized. But we've seen that go both ways in my experience.
Yeah. My experience has been that any federal organizations don't necessarily recognize state law. And the power of attorney statute is a New York law. I haven't heard from clients that there are issues with SSA accepting the power of attorney. I do know that like the Treasury Department won't accept a New York State statutory short form unless there's specific language in the document, which we put into the modification section, which specifically indicates that the agent has the ability to deal with U.S. Treasury securities and savings bonds and the like.
Okay, next question. What is the process to complain about a third party rejecting POA? Who does the agent contact?
Ed, have you experienced this since the changes in June? I'm not sure if it's come up with our office.
Yeah, so if an agent rejects, and really I haven't had a rejection under the new law yet because it's still pretty new. And for those clients that have signed the new document after June 13th, are still all have capacity, thank goodness. So the agents haven't been called upon to act under the new statute. Prior to the new statute, I would get calls on a fairly regular basis. I mean, not all the time, but I probably get maybe half a dozen a year, where the agent calls up and says, I tried to use the power of attorney and the bank says it's not valid for one reason or another. And then it would come down to me contacting the bank and kind of reading them the riot act about, the fact that there's nothing wrong with this document. And even under the prior statute, a proceeding that could be brought to essentially obtain a court order, making the financial institution accept the power of attorney. I've never had to go that far, but the procedure was there. But like Kevin said, with dealing with SSA, it may require some advocacy. But basically, you know, a phone call, maybe a letter to the bank saying, you know, if you don't accept this power of attorney, we won't have any alternative but to bring a court proceeding to make you accept the power of attorney, was usually enough to make the financial institution accept the power of attorney.
Okay, a couple more. Next question, does a successor agent automatically begin to serve if your primary agent is unable to perform their duty, or can you appoint a new primary and keep the successor in that role?
A successor should be able to serve if the primaries, well, I guess what I would suggest is that the successor have some type of documentation to show that a primary is not available. Otherwise, the third party that has a document is going to want to see the primary. So, you know, something to prove that, you know, their authority has now kicked in would be helpful.
Right.
Okay. Next one, both of my adult children live out of the state. Should the POA be initiated in New York State? Do they have to physically be present for signatures? And will that adequately empower them to act on their behalf, even if they don't live in New York State?
I would suggest that the document be drafted in the state where the principal resides. If the agents live out of state, that's okay. They still have the authority to serve. While it's ideal that they can be present at the same time as the principal when they're signing, we understand that's not always possible. Sometimes we have to send out the principal's portion of the document for them to sign, and you know, so long as they follow the statutory requirements, and they can return it to us, and then we can compile the entire document, and it should be good to go.
That's right, and the statute specifically provides that the agent can sign the document anytime after the principal signs it. And we run into this all the time. I mean, not everybody is lucky enough to have children that live in state. So it's often the case that an out-of-state agent is appointed under the document. So we have the principal sign, we ship the document out to the agent, have them sign. And as Kevin suggested, we get the document back, and we're good to go.
Okay, I think we have one last question. Can an agent update or create a new POA once the principal now lacks capacity by adding additional agents or successors?
So we need the principal for that. If the principal is going to amend or create a new document to add agents or, you know, alter agents, we need a principal, and we need a principal with capacity. Agents do have the ability to delegate their authorities to another individual, but I do not believe the statute allows for agents to make amendments to the document itself.
Correct.
Okay, well, I think that is all the questions we have that have come in so far. Thank you, Kevin. Thank you, Ed, for sharing your time and knowledge and taking time to answer everyone's questions. And thank you, everyone else, for joining today. Please take a minute to fill out a brief survey that should pop up shortly. And please join us tomorrow if you're able for our last session of the summer series, and the topic will be on elder abuse. Thank you again.
Thank you.
Thank you. All right, take care.